Hello and welcome. My name is Cindy Heitzman, Executive Director of the California Preservation Foundation. Thank you for joining us at this webinar on commenting on CEQA documents. The format for today's webinar will include an hour presentation followed by time for questions and answers. There's a toolbar on the right side of your screen. If you have a question at any time during the presentation, please type it in the box and I will either reply to you or hold the question until the end for the panelists to answer. Please refer to the audio tab in the toolbar and select if you are listening through the telephone or speakers. To hide or unhide this toolbar, click on the orange arrow. Please adjust your volume on your computer or your phone. Today's presentation will be by Adrian Scott Fine with the Los Angeles Conservancy and Sally Zarnowitz, Preservation Planner with the City of Berkeley. As Director of Advocacy for the Los Angeles Conservancy, Adrian Scott Fine oversees the organization's outreach, advocacy, and response on key preservation issues within the greater Los Angeles area. This includes setting priorities, developing initiatives, working with local governments, and preparing responses to environmental impact reports. The Los Angeles Conservancy is the largest local nonprofit preservation organization in the country. Previously, Mr. Fine was the director of the Center for State and Local Policy for the National Trust for Historic Preservation, based in Washington, D.C., where his position providing research and response on key state and local policy issues affecting historic preservation. From 2000 to 2009, Mr. Fine was the director of the Northeast Field Office of the National Trust for Historic Preservation, coordinating the programs and advocacy efforts in Philadelphia, serving the states of Delaware, New Jersey, and Pennsylvania. From 1994 to 2000, Mr. Fine was the Senior Field Coordinator with the Northern Regional Office of Indiana Landmarks, the largest statewide nonprofit preservation organization in the country. Mr. Fine graduated from Ball State University with degrees in urban planning and development, environmental design, and historic preservation. Currently serving on CPF's Board of Trustees, Sally Zarnowitz is an architect and lead accredited professional who received her master's in architecture from the Harvard Graduate School of Design and her bachelor's in history from the University of California at Berkeley. She is currently the Senior Preservation Planner for the City of Berkeley, responsible for the survey, designation, design, and environmental review of the city's historic resources within the Planning and Development Department. Prior to coming to Berkeley, Sally served as Historic Preservation Officer and Planner for the City of San Jose, was an instructor of architecture at the College of San Mateo, and practiced architecture in San Francisco and New York City, specializing in transportation and adaptive reuse projects. We thank you for joining us.
Okay, good afternoon. This is Sally. So I'm going to start in on my presentation. Remembering that under CEQA, the lead agency's primary or its full responsibility in development review is to analyze and disclose any project-related environmental impacts, identifying ways to avoid and reduce those where feasible, and making overriding considerations and findings of feasibility or infeasibility where not. And the last CEQA webinar and the workshop covered CEQA in great detail, and those are both also available on the CPF website. I also have a cold, so you need to, hopefully I won't cough too much this afternoon. So this afternoon I'll be focusing on how comments can affect these documents, and particularly on how public comment or even commission comments in general can affect determinations about the significance of historical resources, and also can affect impacts by providing suggestions for effective mitigation to lessen and alternatives to avoid significant impacts to historical resources. And I'm going to my next slide. Okay, there we go. So we're going to work on, I'm going to look at the three progressive types of CEQA documents this afternoon. The exemption, and then up to the mitigated negative deck, and then all the way up to the environmental impact report. So this is just reviewing that. Okay, and so under the categorical exemption, let me go back. That went too far. There we go. The agency needs to determine, once the agencies determine whether or not there's a project, we determine whether or not that project could be exempt pursuant to a categorical exemption. But also, the agency needs to determine whether the use of that exemption is barred by any exception. And with historical resources, that exception would be the historical resource exception 15300.2. Stating that a categorical exemption can't be used for a project which could cause a substantial adverse change in the significance of a historical resource. So to answer that question, again, there's two main questions involved in that. The first is a historical resource present on the site? In doing that, there are three kinds of basic resources or categories that would be fall under that question of whether there's a historical resource on the site. So the first would be a mandatory historical resource, one that's already listed on the California Register. The other one would be a presumptive historical resource, one that would be listed on the local register as significant. And the third would be a discretionary historical resource, and that would be up to the discretion of the agency to determine whether or not there's a resource on the site that's significant or at the level of being eligible for the California Register. So that's the first question. And then the second question is, will the project cause an adverse effect on any of those resources, if there are any on the site? So again, the first there's a threshold for whether or not the resource exists, and then the second threshold for adverse for an impact would be a demolition or adversely altering the physical characteristics that convey its significance, such that the resource would no longer qualify for the California Resource Register. So again, I said I'm going to give case studies of each of these kinds of documents. So this is a categorical exemption. And in this case, the first question is there a resource on the site? And there is a mandatory historical resource on this site. This is the 1907 East San Jose Carnegie Library. And it was listed on the National Register in a multi-property listing. It's also on the local register as a city landmark designed by Jacob Lenzen. So that answers the first question as to whether or not there's a resource on the site. And then the second question, will the project cause an adverse change to that resource, such that this would be an exception to using an exemption? So no, the answer on that would be no, in that a technical study confirmed that the addition was in conformance with the standards, and the analysis confirmed that this was a project in conformance with the standards for an addition. So this would not be considered an exception and to the categorical exemption, which is limited to the rehabilitation of historical resources consistent with the standards. And then at the end of the decision, the notice of exemption is filed, and once the decision is made, and that sets the statute of limitation for 30 days. And I'll cover that in the next exemption case as well. So this is an example of a categorical exemption. Also, in this case, there's a proposal on the site for to allow construction of a 6-story, 74-unit housing project. And again, there's that question, first question, is there a historical resource on the site such that this would be an exception to the use of an exemption such as the infill exemption? And this is a good time to point out also that historical resource surveys are really important because they identify these resources before a project is proposed on the site. But in this case, there was no resource survey of this area. And the building was not mandatory historical resource in that it wasn't listed on the register. And it was not presumptive in that it wasn't listed on the local register. So the agency, again, is responsible for determining whether the building is a discretionary historical resource. And they can make that determination based on a technical report, unless in their judgment there's evidence in the record to counteract that report. So once the project is filed, again, the public can comment on the project, but there's no actual comment period required under an exemption. But the public could provide information, for instance, on the architectural history up until the time of the project decision, and also up until the time of a public hearing. So in this case, the city requested a technical report which provided documentation and analysis that supported the conclusion that this 1948 reinforced concrete California modern style church was designed by an architect, Frederick Confer, but it did not appear to meet the California Register criteria. And that conclusion was vetted through a required referral to the Landmarks Commission for demolitions of buildings over 40 years old in the city of Berkeley. And the Landmarks Commission also declined to initiate listing on the local register for similar reasons, that it did not appear to meet criteria. And there was no public comment presented to counteract these conclusions. So therefore, the question as to whether or not there's a historical resource on the site has been answered here as no. And question 2 did not need to be answered because we don't need to analyze a question as to whether or not there's an adverse alteration to that resource. So the project is not an exception. In this case, the infill exemption was used. And again, the notice, after the decision, the notice of exemption can be filed, and the statute that limits the statute of limitation on legal challenges to 30 days. And so going on to another categorical exemption, this is a case in San Jose. A one-story commercial development was proposed on this corner. It's at the boundary of San Jose and Cupertino in approximately 2007. And so the first question was there a historical resource on the site? So there is no mandatory resource. It's not listed on the register, or presumptive. It's not listed on the local register as significant. So a technical report is requested, again, to determine whether the building is a historical resource for the purposes of CEQA in the context to an exception of a categorical exemption. And the evaluation provided information that this 1967 bonsai nursery building was designed by a San Francisco architectural firm, Wertheim, Van der Plug, and Klemeyer. And that supported the conclusion, however, or even the fact that it had an architect associated with it. This building was barely 50 years old. And so even though it had some features of the modern architecture, it did not appear to be distinctive enough to be considered eligible for the California Register. That wasn't a clear conclusion. But in the abundance of caution, the project description was revised to relocate the building on site for use as a store in conformance with the standards. And that maintained the potential for the building to gain significance over time. So again, this was publicly noticed. There was a public hearing on the project decision, and comments could have been submitted up to the time of decision, but no comments were received or questions to the conclusions. And the project was found exempt and met the criteria for the infill development project categorical exemption. It could also probably have used the exemption for the standards. And the notice of exemption was filed, set the statute of legal challenges, and there were no challenges to the project. So the next kind of document under CEQA that we're all familiar with is the initial study with the mitigated negative declaration. And in this case, the agency, when the project clearly doesn't seem to clearly qualify for an exemption, then we move on to decide whether to prepare a negative declaration or an EIR on a project. If the project does not qualify for the exemption, and there's substantial evidence in the record that the project sorry, let me back up on that. So they need to determine at this point whether or not there would be a significant impact to the historical resource. And if there is substantial evidence in the record that the project will have a significant impact on the environment, even if the evidence exists to the contrary, the agency has to prepare an EIR. So the initial study and the MND must conclude that any potentially significant impacts to the resource can be mitigated to less than significant. Sorry. Move forward. And generally, there's a 21-day period, circulation period, and for the a document which called an intent to adopt a mitigated negative declaration. And during that period, the public can review, supply informational on the significance or on comments on the mitigation measures identified in the ND. This is a case in San Jose also on South First Street. This is a transit corridor. A mixed-use project was proposed along South First Street. And the site was primarily associated with the Washington residential neighborhood, which began to develop in the 1870s and was mostly built out by the end of the interwar period, or up till 1945. And the remaining houses along South First Street were replaced with commercial and industrial uses as it became an early auto route connecting San Francisco to Los Angeles and through Monterey. So the technical report evaluated the significance and was charged with looking at the significance of the 6 buildings on the site proposed for demolition. It might be worth noting at this point that through that evaluation, there were other local listings that were found that some of the houses were found to perhaps contribute or be significant at a local lower level of significance, such as structure of merit, or these could be contributors to conservation areas. In some cities, they could be contributors to historic preservation overlay zones, which the agency may not actually find meets the threshold for CEQA, but would be good information for their historic resources inventory in general. But in this case, one of the houses, the Oldham Long House, appeared to qualify for the California Register based on criterion 3. And the house was a distinctive, eclectic craftsman residential design with mission revival influences, including a unique corner tower and details that distinguish it from other houses built during the same period. So the initial study identified and analyzed the demolition as a potentially significant impact. So while photo documentation was identified to lessen the impact, of course it cannot mitigate to less than significant. And I think it's also worth noting other kinds of mitigations at this point. Stephen Schaefer had a great presentation on a CPF workshop recently in San Francisco. He included state-of-the-art mitigations that can lessen impacts to resources, and that's also available on the webpage. In this case, the project description was changed to include relocation into the adjacent compatible residential neighborhood per the standards in order to mitigate the impact to less than significant. And that was identified in the initial study, and that was circulated through the notice of an intent to adopt a mitigated negative declaration. There was no further comment about that, no questions about that conclusion. And the notice of determination was filed, and there were no legal challenges to the document, and the project is now beginning construction. There's another case of an initial study with an MND. This is the Morrison Park project, also in San Jose, 250 attached residential units. They proposed demolition of warehouse and commercial buildings over 50 years old on the site. And the buildings on the site were evaluated for historical significance, again, to see whether there are any discretionary historical resources, and there were none found significant for the purposes of CEQA. So during the notice of intent to adopt a mitigated neg-nec and during the circulation period, substantial evidence came forward and was submitted documenting the fact that the circa 1929 metal-clad and steel-framed corner oil station building appeared to be the earliest on its site, sorry, let me go back again, early on its site within the city. And evidence there could support the conclusion, a revised conclusion regarding the significance of this building as a potential resource eligible for the California Register. So the site plan was studied. Going back to that, you can see up on the left, the lighter circle is where the original oil station was located, and there was a proposal to relocate it on site down to the circle on the bottom right, which is kind of the orange circle, facing the street, also within the same neighborhood. So the project was changed, and when a new impact is identified like that and new mitigation is required to mitigate it to less than significant, then the ND needed to be recirculated. And that is what happened, and proposing on-site mitigation facing the street within the same vintage neighborhood. And no comment was received on the second circulation, and the NOD was filed. The project is currently under construction, and the oil station is being stored off-site, waiting to be relocated. So now just moving on to the environmental impact report and how, again, comments can be made there. When there's substantial evidence in the record that the project will have a significant impact on the environment, even if evidence exists to the contrary, the agency must prepare an EIR. And public controversy itself over the possible environmental effects of a project, that's not a sufficient reason to require the preparation of an EIR. But identifying those significant impacts, and if there is that potential for the significant impact, would be. And there are key comment periods here. Again, there's generally a 30-day notice of preparation with the initial study that would circulate. There should be, ideally, that's recommended there be a scoping meeting to get not impacts, but input on the project description, the significant impacts, the mitigation and alternatives, to help with the preparation of the document itself. And once the draft document is prepared, there's generally a 45-day comment period on that document. And that can be a time that commissions are commenting and the public is providing comment as well. And then during the, at the final EIR phase, there will be a response to the comments, and that would be integrated into that document. There's a certification hearing, and at that certification hearing, once the decision makers need to certify the document, basically they're looking to see that it conforms to CEQA, that the decision makers have considered the information in it, and that it would reflect the agency's independent analysis. And at the time of project decision, an NOD can be filed also to limit the statute of limitations on legal challenges. So that's kind of the overall view of that process, and then on to a couple of case studies. In this case, this is the Ballpark EIR project in San Jose, and it proposed demolition of several buildings greater than 50 years old on the site. And the initial study identified impacts, and there was a notice of preparation circulated for a draft EIR. And there was no historic resource information submitted during the NOP comment period. So that's at the beginning of, when we're at the notice of preparation. And the document itself evaluated resources on the site and found that there were several of them that were not significant. I think there was one that was found to be significant, but the Sunlight Baking Company was not found to be significant. It was one of several evaluated and found not to qualify for CEQA. But during the circulation of the draft environmental impact report, additional information was uncovered, and that confirmed that the 1930s streamlined modern building was designed by noted architect Ralph Wyckoff, and that the building could therefore be found, it would appear then that the building could be found eligible for the California Register with this additional information and be considered a discretionary historical resources for the purposes of CEQA. So when that's the case, when because of that information, a new potential impact is identified and recirculation is required of the document. So the revised portions of the EI, so that conclusion was changed because of the information provided, and that's an example of how providing information can, help strengthen a document or include information that wouldn't have been in there otherwise, and also include considerations for the loss of that resource. The revised portions of the EIR were recirculated, and the impact was identified as significant and unavoidable. The FEIR was, and there was no question, no other comments during that second recirculation period. And the FEIR was certified, and there's no project on that site yet. And this is another case of an environmental impact report, and particularly focusing on how input on alternatives can be effective in commenting on CEQA documents. There was an initial study for a Lowe's 162,000 square foot home improvement store on 13 acres of the former IBM campus in southern San Jose, and it identified the 1957 John S. Bowles designed mid-century modern IBM Building 25, which also included artwork by Lucien Bloch, the ceramic murals. The technical report found this significant as an outstanding example of modern industrial architecture, and also the site of the invention of the flying head disk drive by Ray Johnson's research team, who formerly worked in the IBM building in downtown San Jose on Notre Dame Street. So the NOP was circulated without a lot of comment on the building or itself, but and then the draft EIR was written, and when that draft EIR was circulated, it identified mitigation measures to lessen the impact and alternatives to avoid the impact. But during the circulation of the draft EIR, different alternatives were identified to avoid the impact. There was, so there was alternatives within the document itself, which could have possibly avoided the impact. But also there were other alternatives submitted by preservation advocates during the circulation of the document itself. So the project was actually, the draft EI, so that comment came in, but the response to comments found that there wasn't a significantly different kind of alternative, and that the alternatives that were in the document weren't feasible, and so the project was put into the final EIR, and the project was approved. And a notice of determination was filed, and the decision was challenged based on those questions of the alternatives, And the courts agreed the document did not adequately analyze, and, nor was there sufficient evidence in the record to support infeasibility of the reduced project alternative. And in addition, they agreed that there had been that the new alternatives submitted were substantially different and should have been analyzed with recirculation. And so the court required the decision to certify the EIR and approve the project to be rescinded. And unfortunately, while the before a new draft EIR could be certified, and it was being prepared, and before it could be certified, the building was destroyed by fire in 2008. So the new draft EIR was not able to be certified or address the court order with more alternatives and feasibility information. But it might be worth noting on some level that the educational exhibit that now exists on the site in front of the home improvement store is based on HAB's documentation and educational exhibit mitigation that was identified in the first draft EIR and the second to lessen impacts, although certainly not to less than significant, and that stands on the site today. And then I think this is the last case that I have. This is in Berkeley. This is a streamlined, modern Berkeley Iceland, which is designed by architect William Clement Ambrose in 1940. And the ice rink itself was excavated from the center of the site, and displaced dirt was used to create berms on two sides supporting these concrete pier foundations. So this would be considered a mandatory historical resources for the purposes of CEQA, listed as a city landmark in 2007 and determined eligible for the National Register, listed on the Cal Register under criteria for events and also for design and construction. And on this site, the sports basement proposed a new retail reuse. So the notice of preparation went out with looking for comments, and there was a scoping meeting held, and both of those identified significant concern in the community about the project description, which proposed to remove the berms to meet parking and site circulation objectives for the store. So in response, the draft EIR analyzed removal of berms as a potentially significant impact, looking at mitigation measures to lessen that impact to the extent feasible. I'm trying to move that one forward. It seems stuck. Might get my arrow. There it is. There we go. So in order to approve a project where there are impacts like that, findings need to be made that any significant impacts have been eliminated or substantially lessened to the full extent feasible. So while the draft EIR was circulating, let me go back on this. There we go. While the draft EIR was circulating, the draft EIR identified one mitigation measure in particular to create a silhouette depicting where the berms had been on the site. And you can see that on this image up here with the gray sort of silhouette on the building. But as it circulated, the Landmarks Commission commented on that and suggested further mitigation in the form of a kind of a green wall on the site to strengthen that, to strengthen that sense of where the berm was, and also to beef up the perimeter landscaping and the trees to create, again, to strengthen the sort of buffering that those berms had created. And they also identified the mitigation which hadn't been in there in the document for photo documentation. And so that comment was provided during the circulation of the document. And the response to comments found those mitigation measures feasible, and they were incorporated into the final EIR. And those were used in both the approvals of the reuse project by the Landmarks Commission and by the Zoning Board. And this project is just beginning construction as well. So I think that's pretty much, in conclusion, CEQA alone, I would say, doesn't constitute a comprehensive preservation plan, which is, it's important to keep that in mind, that it itself is not a comprehensive preservation plan, identifying, designating, and reviewing changes to historical resources. However, it does require resource evaluation and analysis to disclose any potential significant impacts. And it gives the public a chance to comment on the evaluation of historical resources, on potential impacts to those resources, and on feasible mitigations to lessen or alternatives to avoid any of those impacts. So thank you. Thanks.
Adrian from the LA Conservancy. I'm going to go ahead and start. And Cindy, if you're able to go back to my starting slide. Great. Thank you, Cindy.
You're welcome.
Welcome, everyone. And thanks, Sally. That was a perfect kind of setup for what I'm going to talk about, which is really to cover CEQA in practice, essentially where the rubber hits the road, so to speak, especially in terms of how citizen activists, the preservationists, and the nonprofit interact within a CEQA context and world. So what I want to talk about is really three things. I'm going to talk about how CEQA has worked both for and against us at the LA Conservancy. So all my examples are going to be Los Angeles County-based examples. Some are those that have gone through the process and have been completed in terms of CEQA. And I'll share a couple of examples that are active projects because I think it's helpful to kind of see how these things play out as you're in them at the time. I also want to illustrate how we insert ourselves as a preservation nonprofit into a CEQA context and a CEQA process. And lastly, I want to share some case studies to kind of illustrate a number of the points that we'll be talking about through this. So if I can advance the next slide. Cindy, do I have access? I do now. Okay. Let me start by saying that CEQA should not be seen or perceived as just another arena where the preservation community can stop things or take on a fight. I think that's a public perception that a lot of people think that CEQA is about. However, I think for a lot of the people that have this perception, we need to kind of change that in terms of how we approach this. Instead, and certainly the way the LA Conservancy looks at it, is that CEQA gives us a process to sit down at the same table, so to speak, and hopefully develop an understanding of the proposed project from all sides. And if we're lucky, we can craft a win-win preservation outcome where we don't just have to be the voice of no or that we're always about opposition. Now, I'm still relatively new to CEQA and how it applies to traditional preservation advocacy, as I've only been in California now for about 3 years. This is kind of my migration pattern. But what I think we sometimes do in California is we take for granted CEQA and just how good it is for us in terms of it helps make sure we're all in the loop and that we have a heads up early on. So in essence, the 11th hour scenario is somewhat avoided. And that's much different from other parts in the country and other places I've worked in the Midwest, in the Northeast, where most cases you are just hearing about a project after it's fully planned and pretty soon to set construction or demolition. So this is really great in terms of having an early heads up and being part of the process as a project is coming together. And while we're lucky to have CEQA as opposed to other parts of the world, CEQA, as Sally was saying, it is not and should not be relied upon as a standalone process in terms of saving and preserving a place. You need the companion piece of advocacy if you hope to have a fighting chance of saving a threatened building or place. Now, the LA Conservancy uses CEQA a lot as a bread and butter component to nearly all of our work. It's integral in saving all these places that you're seeing on the screen right now, from our founding with the Central Library to most recently with the Century Plaza Hotel on the bottom right there. And we've developed a lot of tools to try to help the community understand CEQA. This is a layperson's guide we did a few years ago in both English and Spanish to help people feel comfortable with the process, but most importantly, not to feel intimidated by the process, so it's clear in terms of how it works. And I think that's really important, as you need to build support from all angles and make sure you're not the only group officially interacting within a CEQA process in terms of submitting comments and reviewing EIRs. It's always so much more helpful to have other people that are really part of that process and supporting you. And I think this image says a lot in terms of what CEQA should be about, that it's about having a process to explore alternatives and to generate new ideas, to have a vision in order to avoid the loss of an important historic or cultural resource. So that's, in essence, what it's all about. Now, our history at the LA Conservancy with CEQA is a mixed track record. We've had our great successes with it in terms of saving places, and we've had failures. And I think that's the reality. It's a tool, but it doesn't necessarily predict an outcome. So CEQA was definitely integral with our success in saving St. Viviana's in downtown LA, especially in halting a demolition that was already in progress, and this started back in 1996. And I won't get into the specifics of this particular case, but it ultimately resulted in 2 lawsuits around CEQA and adherence to the law that, and the grounds that we were focused on were in terms of inadequate review and inadequate analysis, as well as there wasn't disclosure of the proposed demolition. Those are the grounds that we ultimately filed 2 lawsuits. And the long and short story of this is it was integral, CEQA was integral in buying us the time and looking at alternatives and ultimately having the building transfer into private hands, a developer in this case back in '99, and now it's saved and it's a great event space for downtown Los Angeles. The flip side of that is this example, the 1920s famed Ambassador Hotel. This was a completely different outcome, a long and sordid saga that I won't even begin to get into in terms of depth, because it really spanned over periods of decades in terms of our involvement in this particular case. However, in terms of CEQA, the Conservancy spent at least 3 years as part of the CEQA process pressing for a process that demonstrated and showed how the school district could feasibly reuse the historic hotel building as part of a new school campus, or build the campus elsewhere on the site and adapt the main hotel building as affordable housing and services for the surrounding community. And that was a big part of what we were looking at in terms of how that could be accomplished. So we engineered our own studies, did our own renderings to demonstrate that this was a feasible option and that this should be on the table in terms of the EIR review process. However, despite demonstrating feasibility, the school district rejected all of these proposals out of hand. And as part of CEQA, we had to work very hard, within the CEQA process, but also within the public realm process to build support and also to set the record straight, as a lot of our facts were attacked and misconstrued in terms of the public realm. Ultimately, we and others filed litigation challenging the adequacy of the final EIR in terms of its ability to explore alternatives to demolition or providing enforceable mitigation measures. And I think what this example, what the story of the Ambassador illustrates for the purposes today, is that you can do everything right in terms of following the process and making sure that everyone's being held accountable and follow all the steps within CEQA, as the Conservancy, I believe, did in this case, and still not have a historic place saved from demolition as an outcome. This was a highly political situation with an entity, in this case the school district, that had a lot of independence, autonomy, And essentially, in terms of acting within the CEQA process, they could act as the judge and jury, and that's exactly what happened here. So I think the message with this is that CEQA is just that. It's a process that does not guarantee any specific outcome. And this is kind of the language in which we talk every day at the Conservancy, every issue that comes forward to us about how we approach things. So it's things like issues like, is there a trigger, or is there discretionary review? What's the timing for the project? Or whether or not the resource is significant and the project maintains its eligibility. This is the language that we talk about in terms of the marriage between advocacy and CEQA, so that we're formulating our strategy and figuring out how we might approach that in terms of a proposed project. And this is the super sexy side of CEQA. This is the reviewing, the writing, the formulating arguments, and submitting comments to notices of preparation or draft EIRs or final EIRs. We spend a lot of time doing this, making our case and argument very clear. And while we work within the CEQA context, we also try to avoid it as well, such as this example of a rehabilitated 1949 building that didn't need to go through an EIR process because the owner in this case chose to do a project that met all the preservation standards, and it was a quicker process, streamlined process, and was really the ultimate win-win. That's what we try to achieve so we don't have to be dragged through a long CEQA kind of EIR process. And I think we certainly learned in terms of our work that time is money, and we've used that to our advantage often in terms of advocacy, especially when pressing for a win-win scenario. In this particular case, I think many of you know the Cinerama Dome in Hollywood 1963 building. In this case, we worked very closely with the development team here as they originally proposed to do a project that would encase the Cinerama Dome where you wouldn't really be able to see it. Instead, we worked with them to do a project that would achieve nearly all of their project objectives, but build around the perimeter of the Cinerama Dome, and essentially kind of highlighting that as a centerpiece for this, which was kind of the win-win in this particular scenario, maintaining eligibility as a historic resource. Or in this case, at the 1967 Mark Taper Forum at the Music Center, we worked with the decision makers there to reconsider their initial plan to expand by building out. And we talked very early with them, even before they had issued any CEQA documents. And it led us down a different path than where they originally were wanting to go. And what it did is it saved them a lot of time. I don't know if it saved them more money, but it definitely saved them a lot more time in terms of the CEQA process. Instead, what we suggested, rather than expanding out, is that they expand underground within the subterranean parking garage, which they had never considered before. So again, by having this dialogue, it allowed them to, and allowed us to put some new ideas on the table. And they reevaluated their initial plan and realized they could meet all of their needs through this approach. And more importantly, it meant that they could meet the Secretary of Interior standards and there would be no significant impact. So ultimately, what they did was a mitigated negative declaration, a process that was much quicker than a full-on EIR route. Sally talked a lot about this initial kind of threshold, whether or not it's a historic resource or not. Advocacy for the Conservancy often revolves around a two-part test in terms of how we approach things. One, we ask this question, is it historic? And two, if so, can we ensure that CEQA maintains its eligibility and status as a historic resource based on the proposed project at hand? The question of, is it a historic resource under CEQA is a basic threshold for invoking the process, whereby we sometimes are in the role of making the case for a building or place being historic, for a place that hasn't been evaluated, or there are some questions about whether or not it's a historic resource. And again, doing that because we want, in some cases, we want the CEQA process to help us so that you can look at preservation alternatives. And that's the case with this particular building. Sometimes there are disagreements among experts, even within the preservation community. And again, that's what happened with this building, the 1965 Columbia Savings Building, where it was not clearly understood or everyone agreeing upon that this was an historic resource when a proposed project, a mixed-use apartment development, was proposed. So we had two preservation experts contradicting one another on whether or not the building qualified as an historic resource. And that's not a good place to be in terms of advocacy and in terms of CEQA when that basic threshold is in question, especially in this case as we were up against the clock, and essentially in this scenario we were forced into an 11th hour as we tried to make a case for this brutalist style building before they had all their necessary reviews in place. And did it in lots of different ways in terms of making our case, and did a lot in terms of trying to establish a context for mid-century bank buildings, which we realized at the time when we did this, around 2008, there wasn't a lot out there, so we were struggling to have some good ammunition to clearly substantiate this as a historic resource. We ultimately ran out of time, as we'd hoped the state might act on a California Register nomination before the city issued a demolition permit. That, obviously, by this image, didn't happen in time. What this taught us is CEQA can help if we have an entire class of buildings and places that are yet to be valued and considered historic, that we had this basic hurdle that we couldn't get over because we didn't really have the knowledge or background. And that really led to the Conservancy launching a special initiative called the 60s Turned 50 that talked about, this era of building in Los Angeles and trying to get a better handle on what was significant, what wasn't, so that we wouldn't be faced with another Columbia Savings scenario like this in the future. And it also, most recently, has launched us into a recent Getty partnership looking at modern architecture in Los Angeles, where we've been looking at buildings from 1940 up to 1990, which launched us into a new website most recently that we have put out there that people can start understanding these resources better. They can search them. They can have a better sense of how Los Angeles developed during this era. And while this is a great tool and building awareness and advocacy, it also helps us establish a base record as more and more of these places become threatened, whereas CEQA hopefully should be in play as we move forward. And we're trying to be proactive with this era of buildings in Los Angeles as building stock. So we recently landmarked this building, the 1965 DWP building in Los Angeles. So we think we're making some strides now so we won't be faced in those situations in the future. This example is the 1959 Lloyd Wright designed Morehouse in Palos Verdes Estates. And this example gets at the adequacy of the EIR and whether a reasonable range of alternatives have been considered. That was the basis of our argument in terms of this particular case. More specifically, whether there's a preservation alternative that's been analyzed and developed that meets a reasonable number of the project's objectives. So what was proposed here, to just give you a little bit of background, the owner of this house proposed to demolish it and to build a new single-family residence in its place. And in Palos Verdes Estates, there is no preservation ordinance or other types of tools to help us in terms of review. However, the city does have a design review process for new construction, meaning there was discretionary review in this particular case, not for the demolition of the historic 1959 house, but for the approval of the proposed house, which you see on the screen before you, what was proposed at least at one time. something in the owner's opinion would fit in with the community better than the mid-century house. So in this particular case, unlike Columbia Savings that I gave you just a second before, there was no question in terms of the significance of this house, and no one challenged it, not the owner, not the city. So in this case, which is unusual to do for a single-family residence, however, the city agreed to do an EIR, a full-blown EIR, as part of this process. And we reviewed and commented on the process all through it. There were a number of problems with the EIR process that we identified. One, we felt like the project objectives that the city, in this case, as the lead agency, that they laid out specifics that essentially were the new house and a Tuscan revival architectural style were incorporated within the project objectives, which would make it nearly impossible for the historic house to ever comply with that. So that was one major failing we felt with the EIR. And two, we felt there wasn't a preservation alternative considered. Not even one that attempted to show how the house could be expanded to allow for more space and meet the project objectives, or in this case, the owner that wanted a larger house. So the Conservancy actually commissioned analysis to show how that could be achieved. It's an unusual house, but we felt that that was possible to do in addition to the building and still maintain its eligibility. What happened in this particular case is that the city chose to invoke a statement of overriding considerations after we went through the full process, saying that the new house outweighed the loss of the historic house as it benefited the public. While we definitely disagreed with that finding and appealed to all levels, this was also another example of timing. The next morning after that decision was made, the owner quickly obtained a demolition permit and demolished the house before we could even go through the litigation route, which was our next step in this particular process. Ultimately, we could have taken this further, as we felt like the EIR process was certainly flawed. But I think this is also going back to advocacy and looking at your work more broadly. And I think this is sort of knowing when to gamble and when to fold question. While we felt we had a strong legal case in our favor, the house was already lost at this point. So we did not pursue it any further on this particular unfortunate example. I think this goes to the issue of finding the win-win. Sometimes it goes to looking at the project objectives and identifying feasible alternatives that would substantially lessen or avoid the environmental effects while meeting most, but not necessarily all, of the project objectives. So that's the case with this particular building, the 1951 Berry Building in Brentwood. This is one of the active CEQA cases that we're involved in right now. The owner would like to demolish this locally designated landmark and building in order to redevelop it as a mixed-use project. However, through the CEQA process and the EIR process, they have, however, identified a preservation alternative, which is shown here, that retains the Berry Building and allows the rest of the mixed-use development to occur. And in fact, the preservation alternative meets nearly 98% of the project's objectives, and while also being the environmentally superior alternative. While we have some questions about scale and how well this is integrated, this has been the preservation alternative that we've been pressing for in terms of the EIR process, and it's going before Planning Commission at some point. And I think this presents a problem for the owner in this case in a couple of ways, that there's what we believe a clearly feasible preservation alternative on the table that's being ignored, but also from an advocacy standpoint, we also have the city council person that has stated on the record very clearly that they're in support of preservation and advancing the preservation alternative. And as you see here, LA Times also came out with an editorial in support of preservation. So again, this shows how the advocacy can be very effective and helpful in working as a companion piece to the CEQA process, that they go hand in hand, that if we didn't have some of these behind-the-scenes political support happening, we would be, I think, somewhat disadvantaged if we were just relying on CEQA to save the day. The next example shows and demonstrates just how effective CEQA can be. And this is really the example with the 1966 Century Plaza Hotel in Century City. As a mainstay of the planned community Century City, the curved Century Plaza Hotel is remarkably intact today. It has been changed very little over time. However, in 2009, the headline that we were faced with delivered news of a project to wipe out the historic hotel and replace it with two brand new soaring slender towers in its place. Quite a lot different than what exists there today. So even before CEQA kicked in, there was no question again about this being a historic resource. However, we didn't want to leave that to chance. So even before CEQA started, we began with the advocacy by establishing the record and supporting it with credible research that backed up the significance of Century Plaza Hotel in terms of its role in the development of Century City. So you see here, as Century City was developing, and you see Century Plaza Hotel under construction there as a core component of that planned community at that time. It involved a notable architect, Yamasaki, and the hotel itself was demonstrated by our research to be very innovative and ahead of its time in terms of how it was laid out, the use of materials, just being very iconic in terms of that period of architecture. So we also delved into cultural aspects to understand it more, that it wasn't just significant architecturally, but it was significant culturally. From its role as the West Coast White House and site of one of the very first West Coast state dinners on the site, to its role as a backdrop to major cultural and current events of the time, Century Plaza Hotel was instrumental and important as part of all of that. We also worked hard to engage people all around Los Angeles County, but really nationwide, in terms of what the hotel meant to them, asking them to sign up for a pledge in support of preservation, which we had over 1,200 people from all across the country that did that. Again, making it very clear that there was a constituent group that cared about this place. And we engaged the local politics as we made the preservation of Century Plaza Hotel a core issue of the re-election of the city council person for this district. That aspect, specifically with the city council support and having a newly elected city council member say, quote, "Demolition of Century Plaza Hotel over my dead body made all the difference in directing the CEQA process toward a preservation outcome and ultimately a win-win instead." So separate from but integral to the CEQA process were about 4 months of the Conservancy, the developer, the National Trust for Historic Preservation, and folks from the city, in this case, meeting for weekly meetings to hash out a compromise, ultimately a preservation alternative that all of us could live with. And that's what you see, and what happened is that this is what was approved and what developed from that process, that CEQA allowed us to come together to come up with a solution or a win-win. And this is the result that was approved just recently, that allows 2 towers to be built, not quite as tall or as large in scale as originally proposed, but it also allows the Century Plaza Hotel to be retained as the centerpiece or the front element of that. It's a give and take on both sides. However, we worked very hard to make sure it maintained the eligibility of the resource, and we feel like it's a good win-win ultimately. And it went through the city planning, the city council approval process with unanimous support, no community opposition which is pretty unheard of for a project of this scale. So there was a lot of behind-the-scenes work that happened, all because of CEQA being in play. So I want to switch gears to another recent example with this, and as you can see, another slide of the approval of Century Plaza. So the other example I want to switch to is at the Port of Los Angeles. We have been working at the port for the past 7 years. Much of it, our work there, advocacy, has been on failures, in our belief, to adhere to CEQA and pressing the port to look at alternatives, specifically on Terminal Island, which is, as you can see in this image, it's about 2,000 acres of the port overall that has, we believe, to be very significant in terms of World War I, World War II shipbuilding, the place where the American tuna industry was born, and then also as part of one of the very first Japanese American villages that was forcibly removed as part of and right after World War II, or during World War II after the attack on Pearl Harbor. Most recently, we have been focusing since 2011 on a master plan that's been proposed for the port overall. And it's not a project. They are going through an EIR, but they're not doing it as a project EIR. They're doing it, and they have done it, as a programmatic EIR, which is a little different. So it's more broadly interpreted in terms of how they're looking at impacts and how they're looking at preservation alternatives. Our primary concerns with the Port Master Plan as it came forward were a number of ways. As you can see on the screen before you right now, one was that they had shown roads going through historic buildings, and they were not identifying impacts in terms of that. They also had land uses that were not compatible for adaptive reuse. So example, having cargo storage land use designated for a site where there's an historic building didn't exactly bode well for the likelihood of reusing or adapting that building in the future. So our primary concerns, again, they weren't identifying indirect and direct impacts on historic resources. They did not provide a reasonable range of alternatives. And lastly, we felt they didn't have land uses in places that would allow for flexibility and adaptive reuse. And on that last issue, we felt that the fact that they didn't have friendly land uses in place as part of the programmatic EIR and the master plan is that would lead to ongoing neglect and essentially demolition by neglect, which we felt would violate CEQA's mandate to avoid environmental impacts when there are feasible mitigation measures or alternatives available. And that's really what we were pressing forward on in terms of this process, that these types of resources were significant, and the plan was essentially ignoring them as it was going forward. So again, this was a behind-the-scenes meetings with the port staff to talk through these issues. Again, CEQA giving us a framework for that to negotiate and to come up with alternatives. The good news is that when the master plan was approved earlier this month, through our advocacy, we were able to negotiate a path forward for preservation. So, example here, last remnants of the Japanese American commercial village. Previous, when the EIR was issued, this was not identified as an historic resource or cultural resource. It is now included within the plan and the adopted EIR. So adding resources previously admitted. We also were able to secure flexible land use designations to allow for and encourage adaptive reuse where there are historic buildings, which was very helpful, which otherwise, if we had not had CEQA, that would not have occurred as well. And I think by this press release that came out earlier this month and showing kind of the partnership between the port and the Los Angeles Conservancy, CEQA alone would not have given us this outcome. but it did give us the relationships and allowed the door to be open so that we could ultimately come up with that win-win scenario. And now I want to switch to the last example, which is really one that is active and ongoing right now that we're involved with. This is Wyvern Wood. It's the first large-scale garden apartment development in Los Angeles. It's in the Boyle Heights neighborhood on the east side. We have been involved with this advocacy issue for 7+ years now to date. And I think Wyvern Wood illustrates all of the various aspects of CEQA in terms of assessing impacts to preservation, from assessing impacts all the way to looking at preservation alternatives, and how this fits in with advocacy, as essentially the two are married, especially in this example. And again, this is just to give you a little bit more context of what it is. You see the downtown in the top of the screen here. The green shaded area is the Wyvern Wood Garden Apartment community. It's 70 acres, about 155 apartment buildings, 1,200 housing units, and what's proposed as part of this project that was announced in 2007 is 4,400 unit development, mixed-use development that would completely demolish everything on site. And it's estimated to be about $2 billion cost for that development. So the question of is it an historic resource? In this case, it was already identified previously in some transportation studies as being eligible for the California Register and the National Register of Historic Places. So we really didn't have that particular hurdle, as it had already been a key component of that, and significant. The Conservancy has spent time doing, most recently within the last year, historic garden apartment context, so that we would better understand how Wyvern Wood fits in terms of the other garden apartments throughout Los Angeles and Los Angeles County, which we have roughly 30 or so of these types of developments. And this is our third garden apartment development that the Conservancy has been involved with that's involved demolition and going through a CEQA process as part of that. So again, this project started in terms of the CEQA process, started in 2008. We had a draft EIR that was issued in January 2012, and then most recently we had a final EIR that was issued in January 2013. Where we are today is it's set to head the Planning Commission and then ultimately to City Council. However, we don't have dates in terms of when that might happen, probably sometime this fall. Much of our work has been looking at the preservation alternative as part of the EIR analysis. We felt there wasn't a wide enough range of alternatives considered, as there was really only one preservation alternative put on the table in terms of the process. And so that's what we're looking at in this particular example. You see the lighter shaded green, that's the preservation zone, or what they would save as part of this project. So we were concerned that other things weren't considered in terms of alternatives. We were also concerned that the project objectives were overly narrow, that they favored new construction. And we felt like there were also some inaccuracies in terms of the analysis that was provided as part of this project, that the EIR relied upon a lot of misleading information or unsubstantiated analysis and errors. So part of our work has been to correct the record and to demonstrate otherwise. So if we focus in just on the EIR as part of this project, this is essentially what was provided as the preservation alternative that included in the EIR, which saves about 60% of the site from what exists today and allows for some new development to occur there. The analysis shows that it does maintain the eligibility of the resource, even though there is substantial demolition. Our focus has been on achieving meaningful preservation, so trying to come up with an outcome or a win-win that would result in that. And the residents, which we're working very closely, they would like to see 100% of the site preserved. So we are starting at the preservation alternative in terms of our advocacy and working within the CEQA process, but we hope to get to a higher percentage at the end of the day. So it's really about looking at the win-win. But a big part of our work has been, again, addressing errors or misconstrued information so that we can have substantial evidence in the record that contradicts claims that have been made and relied upon within the EIR. We've also looked at the project in terms of putting other preservation alternatives on the table. So this is one example that shows how we're trying to respond to some of the project objectives. One of the ideas is to try to get some circulation through the site. Most garden apartments are pretty internal, and that's part of why they're such great places, is because you don't have a lot of streets going through them and you have lots of open space. But in this particular example, we looked at, is there a way to achieve that goal, that project objective, and still maintain meaningful preservation, which led us to a modified preservation alternative that shifted the preservation zone to the west in this case, that still gives you 60% of the site to be preserved and still allows for a substantial amount of new construction, greater density, as well as the circulation that was desired. Again, this was not part of the EIR process. This is something we're trying to advance in demonstrating there are options that have not been considered as part of the EIR process, as it ultimately goes to city planning and city council to show that there are other options that should be considered. And this gives you an indication of that modified preservation alternative. We've also been, again, a big part of the EIR is claiming that rehabilitation and reuse is not feasible. So as part of the record, we have been working hard to demonstrate otherwise, to show other examples, feasible examples, that have shown how that garden apartments can be rehabilitated and meet project objectives and be quality housing that can achieve market rents and whatnot. This is one of the other projects that we've been involved with at Lincoln Place in Venice that also, again, started from a demolition scenario where we showcase similar conditions initially that are similar to Wyvernwood, both exterior and interior. And then we showcase how that, in some cases, the interiors can be modified to include things like more up-to-date kitchens, installation of washer and dryers, or the installation of a second bathroom. All the kinds of things that were made in the EIR claim on Wyvernwood as not being possible, even though these are very similar building types throughout Los Angeles and throughout California for that matter. And then this other example is another similar one, originally started with the premise of demolition, Chase Knolls and Sherman Oaks. Both of these are smaller examples, but they again demonstrate how feasible rehabilitation can be and how they have been able to achieve or deal with the perceived insurmountable problems that have been identified at Wyvernwood, in this case showing how they can add new construction to achieve greater density, which is now approved as a project to occur at Chase Knolls. And then other things that we've been dealing with is, for the record, in terms of the EIR, addressing statements that underground utility lines are a major impediment to preservation, going so far as the owner in this case suggesting that buildings that are over utility lines must be demolished. So building the record, again, showing that, well, that's not accurate. There are actually underground systems for maintaining those lines, and there are other examples of garden apartments and other types of development throughout the city of Los Angeles where you have buildings built over lines and it does not require them to be demolished. So these, again, kind of setting those facts in the record straight so that when we get to city council and if we need to go to a litigation route, it's very clear that this has all been put into the record ultimately as part of this process. And so that's kind of where we're at on this particular project, debunking some of these issues and reaching conclusions in terms of we believe that there are alternatives that have not been addressed. And I think my PowerPoint's now locked up for some reason, but that's fine. And also showing that we think that the EIR fails to provide compelling and substantial analysis demonstrating that preservation is incapable of being profitable by showing these other examples both in Los Angeles and those across the country. We've also looked at the environmental impacts, which is not typical for us as a preservation organization. We try to stay focused on the preservation issues, but in this case, also looking at the environmental impacts of things like this is a 15-year project, so it will generate 11 tons of demolition and construction debris per day over that 15-year period. So that's another aspect that we have focused in on in terms of believing preservation in this particular and active project is the preferable and appropriate approach for the outcome and the win-win. So I'm going to end here because I think we want to do some Q&A.
Okay, thank you, Adrian. If anyone has any questions, please send them in. Right now we don't have any questions. So you do have a few more slides, Adrian, if you want to continue. We'll wait for questions to come. Okay. All right, no one's sending in questions, so I want to thank Adrian and Sally for participating in today's webinar, for leading it. They put in a lot of work into this, and so I want to thank them. And I want to thank everyone who's joined us today for participating in the webinar. You'll receive an email link or an email with a link to a survey, and you should have received a PDF copy of this presentation. If you haven't, please let us know. We would appreciate any feedback on this webinar and any recommendations for future topics. If you're not a member of the California Preservation Foundation, we would encourage you to join as an individual, a nonprofit, a government, or a corporate member. Each member receives benefits, including discounts to all programs, such as these webinars, our workshops, the conference, and our Design Awards program, which is coming up on Friday, September 27th in San Francisco. We also have members-only tours, and we have a special tour coming up of the Oliver Ranch in Guerneville on Saturday, October 26th. Your attendance at this program helps us fulfill our mission to provide leadership to protect California's historic sites and communities through advocacy and education. Membership information is also available on our website. Thank you again for your support, and you all have a good afternoon.